People versus Formosa Plastics Corporation, Texas. We'll hear from Mr. Phillips.
Good morning, Your Honors, and may it please the Court. The fundamental error that was made in this case is that the District Court candidly made a hash out of paragraph 36 of the consent decree, converting it from what it should have been, which is a consent decree implementing provision that deals with discharges subsequent to the date of the entry of the consent decree, and turning it into something that looks like a remedial provision dealing with discharges that took place prior to the entry of the consent decree. The effect of which was to take this very clearly demarcated consent agreement that says for all discharges that took place before December 2019, we're going to solve that problem by, first of all, bringing in a remediation firm to completely clean most of the plastics. Cannot clean all of the plastics. Plaintiffs didn't want all of the plastics clean, recognizing that that would adversely affect the ecosystem of the waterway in this particular instance. Most of them would be taken care of, and then there's a $50 million payment to the trust to provide for additional beneficial opportunities for the environment in that area. But post the consent decree, then the situation is very different. First of all, Formosa committed to no discharges whatsoever, and if there were discharges that were in fact documented by the monitor, those discharges would trigger a $20,000 per instance payment to the mitigation trust fund and a self-report of what is a violation of the permit as a consequence of what the monitor has documented under those circumstances. And instead, what has happened now is identifying mere plastics, the very existence of mere plastics without any effort that's determining whether they were pre or post the consent decree's entry, suddenly triggers the $20,000 payment and the self-reporting that's required here in a way that is undeniably irreparable and does serious violence both to the structure and to the meaning of paragraph 36 and the rest of the consent decree. And you don't really have to go past paragraph 36 to clearly understand that what the monitor is documenting is future discharges or discharges that post-date the entry of the consent decree.
So what's the key sentence or portion of the sentence that you want us to focus on in paragraph 36?
Three of them. I'll start with the one that starts with the penalties that arise, because each of the penalties is based on discharges of a date, right? Either in 2019, right, because the consent decree went into effect in December 2019. There's a discharge as of that date and a penalty that attaches to it. There's 2020 and a penalty, a discharge in 2020, a discharge in 2021. Those are all specific. What is the purpose of documenting a discharge? It is to trigger one of those penalties, and those penalties are specifically tied to specific dates, all of which are dates that are subsequent to the consent decree in this case. Second, the finding is that documented plastics constitutes a violation of the permit. Well, the permit requires discharges. I mean, the Clean Water Act requires discharges. So going back to saying this is a violation of the permit means that there has been a discharge, and that's, again, what are you documenting? The fact of a discharge that violates the permit. And then finally, the third part of it is the provision that deals with the force majeure, which talks about events. And again, why is there a force majeure event? Because it would override whatever the discharge that took place that the monitor has been able to document under paragraph 36. And so as a consequence of that, within 36 itself, it's absolutely clear what's intended. If you go then beyond that and take in paragraph 37, which talks about plastics found by members of the public that are reported to the monitor, and Rule 37 says they have to be new plastics and they have to be not previously identified, which by its terms indicates that the plastics that the monitor is otherwise identifying in Rule 36, and it refers back to Rule 36, again, talking about new plastics that have been identified by the monitor, that have not been identified by the monitor. And then when you get to Rule 30, or to paragraph 38, again, it talks about a discharge of plastics, talking about an action going forward. And under those circumstances, you have to report that discharge to the Texas Environmental Quality Commission in order to comply with the consent decree as it goes forward.
If we decide that you're right, I'm not suggesting we will or we won't, but if we decide that you're right, what should we say and do? Summarize for us what the proper thing for this court to write would be.
The court would reverse the decision of the district court and hold that before there can be any kind of a trigger of an obligation on Formosa's part to pay to the trust fund and to self-report to the Texas authorities, the monitor must determine that these are, in fact, post-consent decree discharges and must document that fact. I mean, it's not enough that he documents the presence of plastics. And you know that because there is language in the consent decree, later in the consent decree.
Again, and following your line of reasoning, and again, I'm not suggesting that we might decide it that way, but if we were
happy to write the opinion for you, Your Honor.
Why is it that we would not first need to send it back to the district court either on a full or limited remand for additional fact findings before we can actually make that legal determination?
Because I don't think there are any other facts that go to the question of how do you interpret this paragraph of the consent decree. I mean, the district judge's determination is that any identification of plastics is itself sufficient to trigger these two obligations on Formosa, and what you're saying is that's not true. It has to be more than that.
Okay, so how do you square up? I mean, it's clear that at least on a lot of the plastic, I understand what you're saying. If the animals have taken the plastic and made it part of their nest, you're not going to go remove it. But it's just a random plastic sitting there that has sat there for 10 years. That, to you, is in the remedial cubby.
Right.
Then if you all discharge the plastic today, that's in the we're going to penalize you cubby.
Right.
How do we distinguish, maybe is the wrong term, how is it distinguished between the two? How can that be distinguished?
Well, I think what the monitor would undertake to do is to look at the circumstances that might have given rise to the possibility that those plastics exist at the point where they are and why they are. Remember, these are not continuous discharges. These are discharges that arise at either, usually because of after rain, or for some other unusual reason. Those discharges are monitored. There are surveillance cameras at every point of discharge. So the monitor can always go back and say, is it possible that this has come from something more recently? And if he can't find anything that would indicate that, then he should reach the conclusion that this is probably there from before. And that's not the end of the world, because obviously there's an entire remediation project underway that's moving down Cross Creek in a systematic way and is designed to remove most, not all. Plaintiffs didn't want all, and that's fine, but it's designed to remove most of the plastics. But the reality is that under his understanding of the district court's understanding of this, this consent decree will never end, because there will always be the ability to find plastics. These are tiny. They are deeply embedded in the soil and in the vegetation, and animals and things that move through them are going to dislodge those plastics, and they'll pop up. And frankly, if you look from the state papers at the pictures of these things, you may have substantially better eyesight than I have, but I have the hardest time figuring out which of those pictures actually identify plastics as opposed to snails. But that's the monitor's job. That was what he was hired to do. He made it clear that he could identify the cause.
But so if, let's say an animal let's say there'd been a piece of plastic there for 10 years and then an animal dislodged it somehow, now it's floating around. You're saying the remediation would still make you pick it up,
yes,
all other things being equal.
Sooner
so it's not a matter of removing the plastic. It's a matter of whether you're subject to the penalties and reporting requirements.
Right. We're committed to getting this as clean as the environment, the ecosystem will permit. That's clear, and we're committed to having zero discharges as our baseline responsibility, and if we violate that, then of course we're subject to these payments. But
so
we want them to make that. The monitor's got to make that determination.
But if there was a dispute over it, if one side thought, and the monitor, let's say, said it was passed, but the San Antonio Bay people thought it was current, you could take that to the district court. You all could litigate that.
We could litigate that. Okay. Whether anybody would, depending on what you're talking about, whether anybody would bother to do that, I suppose is a probably more serious question. But the more fundamental problem, obviously posed here, is that literally every time a monitor or any of the staff of the monitor goes into this property, they will find twice a week or however many days they go, they will find plastic there.
Okay,
if that by itself triggers a payment,
you're saying the district court has taken that piece out, and now every time, and again, I'm just using the hypo of the animal dislodging the plastic. Every time that happens now, you're going to owe a penalty and a reporting obligation, which you wouldn't have paid $50 million to get.
Right, that's exactly right. No sane person would enter into a consent decree that's designed to be a global settlement in which we pay $50 million, hire for tens of millions of dollars a complete remediation program, and then leave it to the ability of somebody to come onto the property, identify plastic that could have been there for as long, for however long, and say, oh, and by the way, every time I find a plastic, I get to add to the ante of those pre-consent decree discharges by $20,000 per item that I find, and you have to report it to the authorities who regulate you.
I have to say, I've looked at this whole thing pretty carefully, and I can't understand how two good lawyers wound up in this situation. I mean, you talk about why are you having to litigate this further? Both sides of this thing didn't do a good job. I mean, it's absolutely crazy that we're all gathered here together in a situation where you have lawyers, law firms, good law firms, who are supposed to figure this thing out and get it done. And here we are.
Well, obviously, Judge Can, I apologize.
You don't have to apologize. That's what we get paid for. But, I mean, it's just... I keep looking at this and thinking, how did these lawyers wind up handling this thing the way it got handled? Both sides. I'm not criticizing you or them. I'm criticizing both sides. It's crazy.
Well, I would have hoped that the district judge, frankly, would have simply honored the consent decree as written, and as most people would reasonably, I think everybody would reasonably understand it, and simply say there is a clear divide between pre-consent decree discharges, post-consent decree discharges, and this falls into the post-decree discharge category and should be treated as such, Your Honor. If there are no further questions, I'll just save the rest of my time for rebuttal.
Yes, you say time for rebuttal. Thank you, Mr. Phillips. Ms. Johnson?
Good morning. May it please the Court. My name is Amy Johnson. I'm here on behalf of appellees, which I'll refer to as Waterkeeper. It's easier than saying estuarine, which is a pretty tricky word. I want to respond, Judge King, to your comment about your frustration with the consent decree. And what I want to tell you is the consent decree makes perfect sense after the trial and the liability order. In this trial, Formosa argued that plastics that were out there were old plastics. They'd been there for a long time. They'd been there 25 years. They couldn't be held liable. In the trial, and this is in the judge's liability ruling, which you can consider even if you consider this an unambiguous contract, there's a Texas Supreme Court case in 2018 called URI versus Clayburgh County, which specifically says even if you think it's unambiguous, you can look at the judge's liability ruling. But in the trial, that argument was made, and we put on evidence that the Texas Commission on Environmental Quality goes out into the creek, takes photos, looks at pellets. That's a discharge. That's a violation. That's how we proved our case. We put on photos. We put on videos. We had huge containers of discharged plastics. And there was not an argument about how they came over. That was their argument, and they lost that argument. Specifically, the judge was given different theories of how to determine the days of violations. One of them was it after a rainfall event? He didn't agree with that. One of them was it when they're out there, have these gates on their stormwater construction? And one of them was, were the gates open? He didn't go with that. The mere presence of plastics outside the outfall is all it takes under the TCEQ.
Okay, but how does it
precedent in this case?
Okay, Counsel, how does it make sense to have remedial and then also treat everything as if it's new?
Okay, so what we did in the consent decree is we limited the geographic area in which a violation occurs. In the trial, there are plastics found all up and down the creek and in Lavaca Bay. And I need to make sure and address the idea of cleaning up most of them. But in this case, under the consent decree, the violations only occur if plastics are found in a discrete area. And there are these booms, and you'll see booms are referred to, these plastic floating devices outside of the outfalls. They go up to the outfalls in a semicircular fashion. And only the plastics within those areas, that's when there is a violation. That's what we agreed to. The word, and I will tell you what we agreed to unambiguously, is what, where, when, how, and who. All of those are in paragraph 32, 33, and 35. What? Plastics. They have to be visible, okay? That's part of the definition. You can see them, and you get better at seeing them over time. They are tiny, but you can see them. That means Formosa can see them, the remediation consultant can see them, and the monitor can see them. So you clean them up. If they're not visible, they don't violate the order. Second, where? In 8 discrete containment areas. This is defined in the consent decree. When? Twice a week. The monitor goes out 2 times a week. Now, the kind of procedures that are being suggested by Formosa would take days and days of investigation. You couldn't do it twice a week. How is it supposed to be done? This is in paragraph 35. I'm going to quote it. The monitor will document the presence of plastics outside of Formosa's outfalls through a log and photographs. That's it. The monitor
Okay,
goes.
but then how do you explain the 4 discharges in calendar year 2019, 4 discharges in calendar year 2020? If something came out there in 2018, that's not covered.
They should be cleaning them up, Your Honor. Okay, they should be. Yeah,
let me ask about that then, because it seems to me, so if I agree to go clean my house, I can't do that this second. Maybe I could by tomorrow. Maybe I could by the end of the week. It depends on how dirty it is, right? But it's not going to be the moment I say, I will clean it, it's not clean. So how long should the remediation take?
Well, there are 2 different issues. Okay, so all we're talking about is cleanup inside the booms. Okay, that's the cleanup is of the creek and Lavaca Bay, and all of it can't be cleaned up because some of it's private property, and we don't know what level of cleanup private property owners are going to allow us to do, or us will allow to be done under the consent decree. But the way the consent decree was written, we negotiated it from June 2019 to November, and then it became effective in January, but the monitor wasn't going to be selected till March. So from November to March, they had time to clean it up.
And is that enough time?
Yes.
Okay.
Yes, it is. And these theories of animals dislodging pellets are just not in the record, and if they were tried in the court below, and it's just not how violations are found under the Clean Water Act. Now, this isn't a Clean Water Act case. We're enforcing a consent decree, but the consent decree is consistent with precedent, and the precedent is how anybody who ever sues Formosa for a discharge of plastics would prove that.
Okay, so you're saying that if they failed to remediate, then that constitutes a discharge. But a discharge when? Again, 2019, 2020, 2021, because the numbers are going up.
The way it always, and I will tell you that that's a compromise. Under the Clean Water Act, it's $54,000 a violation. So we compromise this year, it's 20. Okay, so it is a compromise. It's a compromise in a discrete area. It's a compromise how many times a week. It's a compromise who does it, the monitor. It's all a compromise, which is what the consent decree is. But those discharges, it's the time at which the discharges, when the violation is seen. That's how the agency does it. That's how the judge did it. And that's how the consent decree does it.
Let me ask you this. Taking Judge Smith's hypothetical, what if we ruled against you? I know that you don't want us to, but if we did, how would you handle the remediation?
Well, one of the problems is that if we would have had a detailed finding in the consent decree of what the monitor should consider, because for the most part, the parties are working together on all kinds of issues, and we talk to each other and we try to work together. And there would have been, these are the 5 things the monitor will look at. But my presumption is that the monitor would, I don't think they could do twice a week. I don't think twice a week they could do what they are saying has to be done. But they, eventually there would be some attempt by the monitor to determine, there's just no way to determine when a plastic was discharged. Plastics don't, eventually that biota will absorb onto it and they'll sink. And there's a reason to clean it up inside the booms so that it doesn't sink, and also so that it doesn't get outside into the creek.
What about the cameras? Does that not show if it's...
No. Imagine if you have a camera up there and you're looking for something smaller than an M&M on it. It's maybe like 3 of them will fit into an M&M, a candy.
But you said it has to be visible.
You can see them. You can see them. I could see it on the ground here, just like I can see a speck on the ground right there. There's a little white speck. But from a camera up above, you can. And also, some of the discharges are at night. And so there's just no way that you could, there has never been a requirement by the agency or by the court that anybody watch the plastics come over the water.
But and then thinking, okay, I understand that today if we were just walking in to say you've committed a violation, you look and you see this plastic, that's your argument. But this was, as you say, a compromise, a consent decree, and they paid $50 million. They didn't just say, we'll clean it up, but we ain't going to pay nothing. So what were they paying the $50 million for, if not for the fact of past plastic?
They paid them for past discharges, and they didn't agree not to discharge at all. They agreed not to discharge plastics. And if there is evidence that they've discharged plastics, which is the visible sighting, the monitors log, the monitors photographs it, they get and we get once a week, they go clean it up. If there are more plastics next week, that is evidence of a discharge. That's what the agency does, that's what the judge did, and that's what we agreed to. And so if they were
no way for old plastics to find their way to the water?
I'm sorry?
There is no way for old plastics that have been, this whole notion of the animal discharge, where there's no way for that to happen. If there was a tornado that whisked up a muddy area, that couldn't bring plastic. I'm just trying to understand. I just don't know.
No, I'm just full of facts, unfortunately. But you can have an old plastic on Formosa's side of the fence line, and it can be discharged today. So there's just no old versus new, and all the experts agree on that. There's no old versus new plastic. The idea that the plastics are somehow embedded and deep in the dirt and dislodged is not in the record before the district court on this issue, and is hypothetical. And there have been, post-decree, I can tell you there have been footprints of animals, but there's just not any of the evidence that they're trying to say that they're going to somehow be held liable. You just go clean it up. And if the requirement to clean it up doesn't exist, then they leave them out there, right? And they say, and the monitor goes out the next week, and they say, well, that's last week's pellets. And the monitor goes out the next week. What if he sees more? Well, that's last week's pellets.
but last week's pellets doesn't help them now. It's last decade's pellets that helps them. In other words, if they were to say the pellet you found today on March 31st got there on March 10th, they're still going to owe the whatever it is, $20,000. Okay. What they're saying though is that there's just existing plastics that are just sort of hanging out and kind of always will, and they have remediated and they are remediating, but they can't do all they'd like to do. And I guess I'm just trying to understand, like, maybe we're not really are you saying it's all theoretical, that this is all new and we're just talking about theoretical old plastic or whatever?
I am saying that the way that the cleanup is written says that most are cleaned up, and the remediation consultant finds that any more cleanup will do ecological damage. We are not here in front of you where that finding has been made. There is nothing restricting complete cleanup inside these discrete remediation areas. It's just not the fact before us.
Isn't that a violation of the remediation portion rather than this paragraph 36?
No.
Okay. Why not?
Isn't the failure to clean it up? The incentive, the remediation portion is a huge plan. There are two different issues. One is ongoing cleanup, which is clean up inside these booms, and one is a bigger remediation plan, which is to clean up the entire creek, dig deep into the soil and get pellets out, and to clean up the entire bay. And these are huge, big plans. The one that we're talking about in front of you is these discrete areas where the consent decree mentions ongoing cleanup, the judge's order discusses the cleanup, and there's an entity that cleans up inside the booms, the restricted booms. And you'll see we talk some about how important it is that those booms are maintained, because if you can't maintain them, like I said earlier, the plastics get out and you can have a trickier cleanup in the rest of the creek. I did want to just answer your question, Judge Smith, about standard, how if you assume you determine it's ambiguous, right, or you want to send it back to the district court, there are three different ways to look at the judge's ruling. And I will say, I do think that Judge Hoyt probably knows more about plastic discharges. After, we had 600 exhibits and 5 days of witnesses and experts, and he is quite familiar with how plastics end up in these areas and how discharges are proved. But there'd be three different options. One is to remand. Another is you can look at his ruling and you can look at the facts that he considered and imply factual arguments to support his ruling.
Infer,
sorry. Yep. Thank you. And I had infer written down. But anyway, and the third is that you can take any evidence in the record to uphold his ruling. So those would be the three options if, remand or the other two. I wanted to discuss a minute the idea of that the judge's ruling that Formosa can come back to him is somehow a modification of the consent decree. The consent decree has a dispute resolution process because we knew we wouldn't always get along. And there is a very specific process where the parties are required to give a specific notice. We say who we give it to, 30 days of negotiation, and then we can go to the district court. If there are animals out there digging up the pellets and Formosa can see it and prove it, we can take that to the district court. We can negotiate it. But we also can take it to the district court, and that kind of precedent can be established as to how to manage these issues.
The other thing that Mr. Phillips said, as I wrote it down at least, he says, according to the district court's understanding, this consent decree will never end. I'm sure you're going to differ with that, but What, would you evaluate that, please?
Of course, and we want it to end, Your Honor. There are some very specific ways in the consent decree when it will end. We haven't talked about it, but there's an elaborate engineering process, and the engineering process will have them redo their stormwater so that they don't discharge unless there's a certain kind of rainfall event, redo their wastewater facility, work on what's called source control, which is the plastics just shouldn't be hitting the ground and ending up in their water. These are plastics in America. This is America's creek and America's banks, and we're trying to stop the plastics going out there. But so one is that the engineering process comes to an end and the parties agree that it's coming to an end. Two is that and when the engineering process comes to an end, there'll be no more discharges, because that's what the engineering process goal is. The second will be that the remediation has finished. And so when those two, the monitor could still be going out there, but at that point, when then there will be an agreement that we've finished all the cleanup we can do. No more cleanup can be done, which, or more cleanup will cause damage. And the place has been re-engineered. We're in cutting edge world of plastics, but we will re-engineer it so there's better source control so that the plastics don't end up in any water stream and don't end up outside of Formosa's facility. I still have a minute left, but I am happy to answer any more questions, but I also don't want to take your time if you don't have any other questions.
All right, thank you, Ms. Johnson.
Thank
Phillips, you save time for rebuttal.
Your Honors, I'll be brief in rebuttal. First of all, whatever happened in the liability determination is beside the point. The parties entered into a consent decree based on the facts in front of them, and there's no such thing as law of the case. And so to the extent that presence may have played a role in the determination of what the trial judge did, the case was settled, and it was settled for the purpose of eliminating all that had happened before that. And so what you look at is the four corners of the consent decree. And within the four corners of the consent decree, it tells you when presence is itself a defining factor of some kind of responsibility. But that's an...
Well, why have you not already remediated this limited cubby that your opponent talked about?
Well, the consent decree envisions that a remedial firm be hired to do a comprehensive approach to this. And we're following the advice of the remediation entity, which is going down systematically in order to guarantee that we clean the entirety of it. So I don't think anybody's saying, well, you guys should have done it some other different way. We're getting to it as...
Well, she's saying you had 5 months and could have gotten it done.
Well, we're following what the consultants say, and if somebody wants to tell the consultant to go ahead and do it some other way, that's fine. But in the interim, it seems to me that the monitor still retains the responsibility to make a determination as to whether or not this is pre or post consent decree discharge. And it's important to remember, the monitor, she says it can't be done. The monitor expressly said that if given full access to the facilities of Formosa, he could make a causative determination with respect to all of these plastics. I would hold him to that responsibility. And whether he can do it in twice a week or not, I suppose, depends on how many resources he's prepared to devote to this. And obviously, it's against my client's best interest in some ways, but we pay for that. And so if it requires more in order to get this implemented and done, I'm quite confident the client will be happy with that. As to the question of whether or not animals or other mechanisms create these plastics, the answer is clearly yes. The remediation plan recognizes that as you go along, you have to exclude animals from the area and do everything you can to maintain the area without ruffling up too much of the soil, because as soon as you start shaking up the soil, you're going to throw plastics into the air. So the idea that that's not happening, candidly, is not accurate. And then finally, with respect to, is this consent decree ever going to end? My friend spoke about everything except the provision that deals with the termination provision itself, which says that it ends when there has been 6 months consistent compliance with what has to be decided under paragraph 36. As we interpret paragraph 36, that means no discharges. As they interpret paragraph 36, it means no plastic being found. And in our view, you will never get 6 months where you can find no plastics in an arrangement that is designed not to eliminate all plastics, but only most plastics. So the reality is, this is an agreement that would operate in perpetuity, and no rational person would enter into the agreement under those circumstances. I urge you to vacate and send this back to the district court, Your Honors. If there are no further questions, I'll let you have more time for your lunches. Thank you.
Thank you, Mr. Phillips. Your case and all of today's cases are under submission, and the court is in recess.